Hey everyone, and welcome back to the channel. In today's video, we're diving into a particularly strange and confusing court case involving a tenant who can't seem to make up her mind about anything. She signed a rental agreement for a property, insists she doesn't want to live there anymore, refuses to officially move out, yet has already removed her belongings and claims she's living somewhere else. It's one of those situations where every answer just raises even more questions, and the judge is left trying to untangle a story that makes less and less sense the longer it goes on, to make things even more interesting. This case unfolds across two separate hearings, both packed with contradictions, excuses, and moments that will leave you wondering what exactly this tenant thinks she's arguing for. Get comfortable, because this one is a bit of a ride and definitely on the longer side. Let's get started.
And that's it. So, folks, that's the call. Please move along to your calendars. I asked if you have multiple cases, attorneys, that you try to handle them as many as possible before you come to me, and then we'll address them in turn. I'll look at those defaults shortly. Thank you.
Your Honor, as far as Kiana Johnson, with this case with Pharrell, I'm in the hospital, so I'm trying my best from the hospital. I did submit a letter saying I was in the hospital. I don't have my ADA accommodation, so I'm not familiar with how this goes. Can you please tell me what's next?
Yeah, so all we would do, ma'am, and I really do pray for your swift recovery, whatever that may be, but ultimately it's virtual, so you would be able to still talk with that attorney in a private breakout room virtually.
Okay, I just need to know. Okay, so you all will do that? I don't know how to do
They will put you in a breakout room. You'll see an icon, and folks, this is for everyone. You ultimately will see an icon that says join breakout room. Do not leave the actual hearing, this Zoom hearing, unless I tell you to, okay? I'm the only one who can dismiss you. But ultimately, you'll be placed in a breakout room, and you may have to wait because one of the attorneys may have multiple cases, and then they will address your case in turn. Ms. Johnson, they may try to get to you sooner because you're in the hospital, but we will see. And then ultimately, you'll have an opportunity to determine if you want to settle the case or if you want to have a trial, okay? And if you have a trial, we'll have to have that situated. So just be on the lookout, folks, for that icon to join, and then you folks are free to do so.
Sorry, that was my doctor. Sorry.
No problem. Thank you for being patient. If you can raise your right hand, we'll get you out of here. You swear affirm to tell the truth under penalty and perjury of the law?
I swear.
Counsel, wait 1 second. What are those terms?
Judge, this one's a little different, just to be kind of very open and frank with the court. So it's going to be an agreement. Both parties are going to dismiss with prejudice their claims and their counterclaims. Miss Johnson's lease ends on September 30th. She has agreed that if her stuff is not removed by September 30th, those items will be deemed abandoned.
Okay.
And if Mr. Thomas, who is the plaintiff, he and his wife own the property together, that if they find anything like that she leaves behind that may be considered valuable, that they will notify me, and I will reach out to her and arrange for her to be delivered that.
Okay.
And then with respect to the security deposit, that the parties are going to sign a mutual release, and that when that is presented, they will sign it, and then after it's been signed, which I will prepare and give it to Miss Johnson by hopefully tomorrow, that the security deposit of $1,000 will be paid towards her, available for either pickup at our office, or I will be happy to FedEx it to wherever she wants me to FedEx it to. Does that make sense, Your Honor?
A little bit, but let me see.
Sure.
All right, Ms. Johnson, just to confirm, I just want to confirm the terms. The parties are both dismissing their cases, claims against one another, but ultimately you've agreed that you will move out your remaining possessions on or before 9/30/2025, and anything remaining will be deemed abandoned. However, if there is anything that deems valuable, the parties will hold and contact you so that you may retain it or kit it. Moreover, the security deposit will be addressed upon your move out, which you guys will do a move out walkthrough as well. Counsel, is there anything else? No money judgment?
A negative. The security deposit's not quite right, Your Honor. So it's basically
Oh.
she's going to waive a right to, or we're going to waive our right to the security deposit. We're just going to give her $1,000, and she's going to sign a release, and my client will also sign a release.
Okay, so forgive me, Ms. Johnson. So in lieu of that, you will get $1,000 portion of the security deposit, or just $1,000 just in general.
Yes,
from
as
the
a
plaintiff.
judgment. Yeah.
Yeah, and then that will resolve the security deposit issue as well. Anything else that I missed? I'm sorry. You guys got quite a bit.
Is that
Question.
correct, Mr. Farrell? It's not the security deposit. It's just $1,000 judgment, correct?
Right.
Well, it's not a judgment.
No.
But
No. I didn't say anything about a judgment. We agreed on $1,000 of the security deposit. I don't want any judgment against me or my business or our company. A judgment? Am I clear? A
So
judgment?
what is the clarity, Mr. Farrell?
Yeah, can you clarify?
sure. I guess it really is coming from the security deposit, but maybe I shouldn't use that word. There'll be a waiver of the security deposit. My client will pay her $1,000 upon the.
All right? That wraps up the first hearing. I decided to include the entire thing for two important reasons. First, I wanted you to hear, word for word, the exact agreement she made with the attorney. There's nothing like hearing it directly from the source, especially when later parts of the case depend so heavily on what was said in that moment. Second, there's another reason I wanted you to see it. A reason that's going to make a lot more sense once we get into the next hearing. There are certain details and contradictions that only become clear when you've seen how everything started. So keep what you just heard in mind, because it's going to matter a lot more than she expected.
Just so we're clear, I understand. I know Mr. Attorney Farrell is clear as well. But security deposit, they're not going to be keeping all of it regardless. Out of that, you're going to get $1,000 of the security deposit that you've already paid, and that is upon signing in a mutual release. Again, the parties are dismissing their claims against one another. You'll have to the 30th to remove your remaining possessions. Anything remaining will be deemed abandoned. However, they will keep it and potentially, if it's valuable, and contact you about it. Furthermore, upon that. Yep, that's what life likes to do to you.
Your Honor, if I may, just for clarification, she used the word judgment, and I'm no lawyer, but we didn't agree on any type of judgment. This is a mutual, amicable agreement.
I got it, Mr. Thomas.
Yeah, no judgment. We had an agreement.
I understand. But I need to wait for her to come back.
Yes, sir, I understand. Just
Ms. Johnson, can you unmute and turn on your camera? Here we go. Can you unmute for me?
Yeah, I'm sorry about that. I'm getting blood drawn and it just.
I get it. We're going to make it real quick.
Okay.
You agree that the terms are that you guys are dismissing your claims against one another, that you're going to be vacating on or before 9/30/2025, that any possessions remaining will be deemed abandoned, that anything that deems valuable they'll contact you about. And furthermore, you'll do a final walkthrough. Well, ultimately, after you sign an agreement, they will return $1,000 of your security deposit. Are these the terms that you've agreed to?
Yes. The walkthrough of the security deposit would be returned. He said within the next week.
Okay. Well, you guys would also be required to sign a mutual release.
Yes.
Okay. Well, then I will get a proposed order from counsel, which I'll review and sign, and then I will get a copy over to you. And I pray that you do well and you get better. Okay.
I appreciate it. Thank you.
All right. You guys are free to go.
Thanks, Judge. Appreciate it.
thank you.
Don't worry.
And this brings us to one of the stranger parts of the second hearing. The judge asks a straightforward question. What exactly do your mental or cognitive challenges have to do with the fact that you voluntarily agreed to move out of the property? It's a fair question, because throughout the entire hearing, she keeps circling back to her personal conditions as if they somehow undo a written agreement she willingly signed. And I don't know about you, but this is honestly the first time I've ever heard someone claim that mold in a home can worsen a learning disability to the point that it affects a legally binding decision they made weeks earlier. It's an unusual connection, to put it mildly. The judge is trying to understand how any of this is relevant to the actual issue. She agreed on record to vacate the property. Yet now she's trying to weave unrelated explanations into the situation, hoping it somehow changes the commitment she made. This is where the case starts drifting into territory that's confusing, inconsistent, and frankly, unlike anything I've seen in a rental dispute before.
Attorney Farrow,
Yes.
did you or Mr. Attorney Sinquit have an announcement?
Your Honor, I do. I have a pay and stay agreement on position number 4. And I still have one more tenant to talk to. And I know the court's considering position number 1.
Yeah, and so I just real quick so I can get to deal with Ms. Johnson. Ms. Johnson, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
All right, so listen, I've read over your motion. I do see that the original judge had given an order for you to pay in the registry. I do understand that you had certain other conditions and that it was ultimately, that may have altered your ability to do so. And then some other things occurred. Those issues, though, don't necessarily materially address the issue of possession. They're totally fine for counterclaims, but they don't address the issue of possession. Obviously, your condition would really justify you leaving the property, right? So,
May I speak?
sure.
Okay, so as far as the position there, I did go into the property with an ADA need. I had an allergic disorder. That was addressed to the homeowner, and he said that he would make sure that there were no allergens in the home while I was there. A major allergen would be mold. That resulted from an unrepaired and unresolved and refusal to resolve without in a manner appropriately and timely. And that
Objection.
I would before.
So
Your Honor, we already dismissed the claims and the counterclaims. I think we're in front of the court on a motion to enforce what she contended is an oral agreement. It has nothing to do with everything that happened before.
I'm not.
Well, hold on. I see an order. I see an order for continuance. I see a motion to compel rent, an order regarding such. I don't see a consent order, but I do see the motion to compel rent into the registry, which is the basis, I believe, why the writ was requested, because the $1,300 was not paid in the registry. Is that correct?
Your
No,
Honor,
Your Honor.
You said no.
No, Judge, you signed an order that should be part of the record, which I can, share the screen.
Hold on. If it's been, I'm sorry, I saw them. It seems like there's been 2 judges. I see Block's been on here as well. So hold on.
Mm-hmm.
I see this oral agreement. But counsel, you're saying there's a different agreement? I mean, this alleged oral agreement where she's...
Judge, you signed an order. It should be in the docket. I can share the screen.
I think I had the position first. He objected. Can I go back to my position?
Just hold on. I want to see what I'm looking at first. Okay, so there's a consent agreement. That's important. And so the consent agreement indicates parties have agreed that defendant Keena Johnson and all others will vacate the property located at 2179 Diller Crossing, Tucker, Georgia, on or before September 30th at 5 p.m. and that anything left behind shall be deemed abandoned and may be removed without further order of court. Plaintiff sees anything valuable. Yeah, I feel like I remember this case. Further ordered and the judge, plaintiff's complaint, defendant's counterclaim. Yeah, so I understand. What's going on? Today's the 30th, Ms. Johnson. You signed a consent agreement. I'm not trying to be difficult with you, but there's generally no appeals, of the consent and modification and such.
Your Honor, I'm respectfully asking under my conditions for a chance to speak.
Sure.
And I'm going to speak by narrative, if you don't mind.
Well, I would ask that you just be respectful of the time and address specifically. So hold on. Let me ask this. Why do you believe that the consent order which you signed, saying that you would vacate by the 30th and dismiss all your counterclaims, why should that essentially be not considered in lieu of your signature on such? Or in lieu of the agreement that I find that you've entered into?
Your Honor, the reason being, and before I go into that, I will say that I did ask for ADA accommodations. I am a disabled party. I asked for ADA accommodations. That was requested on August 26th. Before that, in a different...
What you heard in the courtroom was spoken casually, in everyday language, because the judge and the attorneys were trying to make the agreement understandable right there on the spot. It was explained in simple, straightforward terms, so there would be no confusion about what you were agreeing to. Later, when you received the written version, it was presented in formal legal wording, which can look more complicated even when it isn't. But despite the different phrasing, both versions communicated the exact same agreement. Nothing was changed. Nothing was added. Nothing was hidden between the lines. The written document simply translated the plain-spoken discussion into the proper legal format. That's how settlement terms always appear once they're put on paper. They have to be written in a very specific way to be legally enforceable, and the agreement itself couldn't get much more straightforward. You move out of the property. You drop every claim you've made against the landlord. In exchange, the landlord agrees he won't file any claims or take any action against you. He keeps the security deposit, which is standard in a situation where both sides are agreeing to walk away from the dispute. And he pays you $1,000, reduced only by any legitimate damages that exceed ordinary wear and tear. That's the whole deal. No tricks, no loopholes, no secret clauses buried in paragraphs of legal text. It's simply the formal written version of the very same terms that were explained out loud in court. In reality, it's about as simple and direct as a legal agreement can get.
At our virtual
Objection.
And so
Under one
for me to
basis,
be able
Attorney
to,
Farrell, just so I can keep a record of what's going on. Objection for what?
Well, that's not the motion from the court, Your Honor. I'm objecting. The motion from the court is the motion to enforce the settlement agreement.
Your Honor, in order for me to have due process in this court, I do require ADA accommodations for cognitive disability.
Well, ma'am, are you trying to say then that you didn't have the authority to enter into the agreement that you said you had the authority to enter the agreement back on September 2nd?
No, okay, I needed, because I have a cognitive disability under stressful situations, this is why those accommodations were needed, and the breaks.
Well, how do we address that accommodation? I'm not trying to be rude.
There were a list. There were about 7 accommodations. When I'm in another county, I get an ADA coordinator that I work with. I have been asking for a DeKalb County coordinator. I have not been given that. I've been told that we had to wait on the judge to at least address the ADA accommodations. They were asked for reasonable accommodations. Those were not addressed. Those were not addressed at the last hearing. That is not what I'm saying. I'm saying for me to continue forward in the manner in which we are, I'm going to put down that I'm not receiving those accommodations. I need to put that down on record. Part of those accommodations would be a support person for this hearing. Part of those accommodations would be breaks. I just got out of the ICU. My condition has been exacerbated. I've been in the ICU all week. That's another reason for the emergency continuance.
Continuance for what, though?
For this hearing.
But why?
But that's why the ADA accommodations come in.
But we don't really need a hearing. And I'm not trying to be difficult, but you have to take this in consideration of how I'm viewing it. Before these things, or after these things were requested, you voluntarily entered into a consent agreement, right?
Your Honor,
don't cut me off. That's how you get nowhere. Why would you cut me off? That's foolish. So you've entered into this agreement on the 2nd of September, just less than 28 days ago, right? And
not this agreement.
Well, the agreement says September 2nd, and that you vacate by the 30th of September. Stop talking. I understand your physical conditions have changed because of your health, but that does not necessarily disregard the fact that you've entered into a consent agreement indicating when you would vacate. Your ADA accommodations are not relevant because really there'd be no need for a hearing based upon the agreement that you've already entered into. So I'm trying to figure out why we need to accommodate in those regards when you've already entered into this agreement indicating that you would vacate. You've created the time to prepare to leave. That was what your plan was.
Your Honor, may I?
Yeah, you can now, yes.
Okay. So, Your Honor, I've had these disabilities for years. It's not just because of this. They've just been exacerbated by this. The other reason is that when I had the hearing last time, I had the hearing from a hospital bed. I had just had a stroke. I had just had, that morning of the hearing, I had just had an MRI and Xanax. I had just had a procedure. I got to the hearing late. When I got to the hearing, I was right at the point where you all were going to give a default judgment, but then I said hello, and then I proceeded from my hospital bed and my hospital gown. I didn't want to be under those same similar circumstances, under medication, and having this. What I'm saying now is that the reason that I bring this matter back to enforce is one, because what you signed was not what we agreed to verbally, and not what you not.
All right. So they're stepping out for a short break. But before they did, she casually referenced another eviction case involving the same attorney. That immediately caught my attention, so I went digging through prior filings to see if there was anything connected to it. And sure enough, I found another active eviction case with her name on it, this time involving her current landlord, who is also trying to remove her from the property for not paying rent. Now, I'm not jumping to conclusions lightly. People can fall behind on payments for many different reasons, and one eviction case doesn't automatically define a pattern. But when you see multiple ongoing eviction cases involving different landlords, different properties, and different timeframe solves circling around the same issues, it starts to paint a much clearer picture. And based on what we've seen in these hearings, combined with the court records that are publicly available, it's hard not to notice a consistent behavior emerging. Everything points toward someone who repeatedly moves into properties, refuses to pay, refuses to leave, and then ties everything up in endless legal arguments. I don't want to make harsh assumptions, but at this point, it honestly looks like we may be dealing with someone who has developed a pattern of staying in homes without paying for them, a serial squatter. In all but name, clip.
The agreement that he originally sent to me to sign was about 5 pages long. There is history with this counsel, and he did not disclose that. I did try to disclose that with you before, which may be a conflict. The history being is that we're on a similar case in another county, and that similar case it has the same similarities, health-wise, landlord-tenant-wise, but that case is confidential. The reason being here is that I just found out today that he subpoenaed my medical records. He subpoenaed my medical records, and I just found that out today. I was just giving that.
But let me stop. And I understand your situation, but I'm again looking at my notes from that hearing on the 2nd, and it says consent vacate by 9/30/2025.
And that's about all it says. But the agreement that you signed, that he had you sign on September 10th, we have been going back and forth after the hearing. Since then, he tried to get me to sign something that was totally different language than what you said in court.
But I'm only referring to what I have in court.
Yes, but what he drafted for you to sign is not what we went over in court. That is not the agreement we made. It does not only say September 30th, get out. It does not only say that. It says the property that you'll have and anything deemed, and they'll essentially keep a value and try to have you talk through counsel. So listen, I respect you and understand that you have certain conditions. I'd like to remind you that you're telling me that the property is uninhabitable while also trying to demand to stay in the property. I'm not asking, Your Honor, I'm not asking to stay in the property. I've already addressed in my motions that I have signed a lease somewhere else. I have been out of the property for the last 3 months. The issue is that I cannot, it's uninhabitable. I cannot go in and get my property, which includes my dad's ashes, my son's autism medications, all those things. Who can go in? The property I have tried to. Are you there right now? When I tried to go in. Are you there right now? I don't live there right now, but my all our belongings are there. Are you in the property right now? What do you mean? Are you physically in the property right now? I am in the temporary housing property where I signed a temporary lease. I'm on my 3rd month of rent. Okay. Because that house is uninhabitable. And that's fine, but that has nothing to do with ultimately you getting the remaining of your possessions out between the 2nd and today. The agreement. So listen, respectfully, what I do know is that you've agreed to vacate. There's nothing in here indicating that you are required to pay rent or anything like that in the consent agreement. So Attorney Farrell, I'm not sure about the writ that's been requested, because I believe the writ indicates that she's missed a payment. Now, I believe that may be associated with a prior order from the prior judge about being paid in rent, but it appears that the most recent order and the most that would be effective is the consent agreement that was done on the 2nd, indicating that she'd vacate by the 30th of 2025. That's it. So whatever your writ wouldn't be signed as is currently identified, because that's based on a prior order that has essentially been overtaken by the consent. So at this juncture, I would need a new writ. Ms. Johnson, what I would tell to you is that they have to submit a new writ. I do have a consent agreement where I have you under oath confirming to those terms. The end of information here Your Honor, I was never under oath.
Literally didn't say that, and I've already played the proof. Every word is right there on the record. And with all due respect, it's incredibly frustrating to watch someone rewrite reality when the actual audio has already been presented. This isn't a situation where things are unclear, or where two people simply interpreted the same conversation differently. No, this is a case where the exact agreement, the exact language, and the exact terms were laid out plainly in court, and then laid out again in the written document. Yet somehow, despite hearing it with her own ears and seeing it in black and white, she still insists that the deal meant something completely different. It's like she's operating in her own separate version of events where none of the facts, none of the statements, and none of the court instructions matter unless they support what she wants to believe. And what makes it even more unbelievable is that the judge patiently clarified the terms. The attorney clarified the terms, and the written settlement matched those terms perfectly. There's no hidden meaning, no legal trick, no surprise condition. It was all completely straightforward. But instead of accepting what was actually said, she keeps trying to claim the agreement promised. Something entirely different, something that nobody in the courtroom ever stated, implied, or agreed to. At this point, it becomes clear that the issue isn't confusion. It's denial. She heard it, she read it, she still insists on a version that simply does not exist. Clip.
And will not cover damage of any of those property defendant can. So you guys never signed that release. I see that was I guess that's the oral agreement that you guys have been referring to.
I'm trying to continue
to pay $1,000 from her security deposit for fitting the remainder.
They added language to that consent agreement that was not part of the agreement is what I'm trying to get to.
Okay, and which part?
It's the part where they say that the $1,000 security deposit, they have, when they presented me with an agreement to sign, the release to sign in order to, there was no contingency basis, first of all, for me to sign that release in order to get that $1,000, but they put that down there. They also were supposed to, if I didn't get all my things out, given the consideration of the situation, they were also supposed to, they agreed that I would give them a forwarding address. They would allow me to get some of the most personal, valuable things back. And so they changed that.
It says if plaintiff sees anything valuable. Well, and that's not what it says in the order. It says if plaintiff sees anything valuable, plaintiff will reach out to the defendant through counsel to have it picked up.
No, they agreed not to pick it up, that they would give it to an alternative address. They would send it. The other thing is that
Negative, Your Honor.
So Ms. Johnson, I'll be frank. You know, I'm going
to file a motion today. Go ahead.
You can do what you want because that's what's legal. I'm not.
But that's not what the agreement. My argument, Your Honor, respectfully, is that there's more to it than that. That is not what the agreement was. When they tried to sign the release, they tried. The reason I bring up the other case is because the other case had language that he tried to include in this case. This case had simple language, and he gave me a 5-page thing to sign that excludes that, and the other.
I understand, but all I'm saying, Miss Johnson.
You got to give me a chance to finish under these conditions. I do. That's why the ADA accommodations were necessary. They're not because
it has nothing to do with that. I'll be frank with you, your ADA accommodations don't justify. You're speaking fine. You don't. You're not sound. I'm just telling you. You don't. There's nothing that you're saying that doesn't seem as if you don't grasp what I'm saying, or that you need aid. And indicating what you're telling to me is that you have an issue with this particular order. One of which I'm not quite sure, because what you've already said is that what's on this order, which is 1 page, right? 1 page. So I'm not sure about what else you're talking about, but the order that I'm referring to is 1 page, and I've already read it, and it's a consent agreement.
There's one more thing, Your Honor, if you let me. On the order, when we talked about this, the security deposit, it was in lieu of the security deposit. He was not allowed to go, and what he tried to put in the new agreement for me to sign in order to get the $1,000, that was cost to help me move out, not for him to move me out, but for me to be able to get my things out.
Let me just read it so I make sure that you are reading. So it says in this last portion, further ordering the judge, the parties will sign a mutual release agreement. The mutual release will not cover damage, if any, done to the property by defendant or any other occupants. When defendant Kiana has signed the mutual release, she will be paid $1,000 from her security deposit, forfeiting the remainder.
No, Your Honor. What they basically, I still have to sign their version of a release to get that $1,000. I was not able to do that because their version of that release does not state what is on that order. It actually states that I'm sorry. This is where I probably need a break, but I don't have those accommodations.
Well, how about we do that? Why don't I give you a break and I'll move on and I'll come back.
I can give you.
I think it would be appropriate based upon everything that you've made clear to me that it may be best for you to have a break. I'm not making an order yet. So why don't you take a break and we'll deal with the other cases.
How long will the break be?
We'll see. I'll see how long the cases will take.
Okay,
A break is better than no break.
That's fine. I did want to put out there that I would like to request to disqualify Attorney Farrell because of the conflict of interest we have. That case is without prejudice. That case is ongoing. Attorney Farrell is using some of the things in that case.
Well, let's take a break, right?
A return to condition of normal wear beyond normal wear and tear, but that goes with statutory security deposit requirements. There can't be normal wear and tear because there's already water damage. They haven't included that. They're going to try to tell me that I did
I don't know what they were going to try to tell you because obviously you guys would have a mutual release.
But we did not. It said in lieu of the security deposit, and I
get that.
Yes.
So, Attorney Farrell, your response.
Your Honor, we did have a little bit of a kind of a normal standard release, and then we basically reduced it to one sentence. I hereby release all of claims unconditionally against the landlord, and if you sign that, we'll give you $1,000. That's how simple there was a negotiation, and we basically catered to her and to what she wanted.
Object, Your Honor, that is untrue. I have not received anything with one sentence.
Just you can object, but folks, first off, what I don't like people is when you just object and don't file a basis. Then it's a little point. I don't know what you're making me think of whatever you claim is the basis of it. I can think of 1,000 reasons for you to object. But that's not my job. And I'm not just telling you that, Ms. Johnson. You Attorney Farrell as well. You guys are just yelling out object. Object what?
I'm sorry, Your Honor. I was never presented with a one-page release.
So
that is a one-line release. That's not true.
So this is the issue. The issue is she's saying she can't move because you didn't supply the release that was essentially agreeable, which then you're not going to give her the $1,000. She can't get the $1,000. She's saying that impedes her ability to get. Now, that wasn't agreed to, that you were going to take this $1,000 to be able to get people to move. I understand that was your intent, but that
was the agreement. We literally said that.
That's really all there is to it. An online release form, a basic walkthrough of the unit, and a $1,000 payment. It's one of the most straightforward agreements you're ever going to see in a landlord's tenant dispute. No complicated conditions, no hidden clauses. No legal traps, just a clean exchange that benefits both sides and finally brings the whole situation to an end. But now comes the real question. Do you honestly think Karen is going to let something be this simple? Because if there's one thing we've learned from her behavior throughout this entire process, it's that nothing can ever remain uncomplicated for long. She has a remarkable ability to take a clean, easy resolution and twist it into a labyrinth of objections, misunderstandings, dramatic declarations, and sudden new problems that magically appear the moment she's expected to cooperate. So while the agreement itself is simple, predictable, and perfectly reasonable, the real challenge is whether she actually followed through, or whether she somehow turned a three-step process into a full-blown saga. Given everything we've seen so far, I think we all know which direction this is likely to go. Clip.
Party, did you have a response to Ms. Johnson's request and the basis of your opposing her request for continuance?
Yes, Your Honor. I mean, really, it's a very limited issue. She's here. We're all ready to go. But in terms of disqualification, I was representing a landlord against her in a prior case. There was a confidential settlement agreement. I've not made any reference to that. So I don't know the basis of.
I object, Your Honor. He did subpoena medical records, an extensive history of records that go far beyond this case that could go into the other case, and that case can be revisited. And he was not privy to those same records in the last case. He did ask for discovery; those were not given. But he's used this case to subpoena my medical records, a historical amount, not just for what's going on here. And he's created a matter of controversy in order to do that by saying in his response that I could not have been in the ICU and had a visit with my primary care, which was a televisit, by the way. But he tried to say that, and then he subpoenaed her to give a history of all my medical records. That would go back to the 2024 agreement that he and I had.
Not true, Your Honor. She
That is
attached
true. There's a conflict.
Ma'am, let me speak, please. I'll let you speak. You attached medical documents to your motion for continuance. I have a right to subpoena. I've released everyone's subpoena. I don't have any of your medical records. I don't have any of your witnesses. So that
Your Honor, I just got that subpoena today. That subpoena was given to me at 9:45 this morning. I was unaware that he would go that far. I did try to present this conflict. I did try to present this conflict in a motion.
Folks, let me just, can I ask you for really, why do you need the continuance? Let's start there.
The reason I need the continuance is because there was first of all, I just got out the hospital, but in the motion, there was in the agreement, the original agreement, there was $1,000 to assist with move out costs. It was not for them to move me out. It was so that I can get help moving out because I can't go back into that building. You just asked me, you said, how could you get help to move out? I said I couldn't do that myself under those conditions because it's uninhabitable. As soon as you walk in, you're overwhelmed with the smell. Somebody said they would charge me that amount. So I said, okay, but they would not release that to me unless I signed a contingency agreement releasing them of all future claims and all this other stuff and tons of all this stuff. And that was not what we agreed to. And that's what I'm trying to get to. But it's hard for me to vocalize that under stress, is that is not what we were getting to. They delayed giving that to me. They said the only way you'll get that, and they wrote it in this is not what we went over in court, is if you sign this. And he tried to get me to sign a 5-page document that said you won't do this and you won't do that and you will never do this and you will never do that and you won't hold any of us responsible and all these other people, and that was not part of the agreement. It was a simple agreement.